And that's the point, to convince each other, persuade each other, put different forms of data on the table and points of persuasions in order for us to grow. I was reading a very interesting piece in the Mail and Guardian of recent, and it was penned by none other than Christine Qunta, the chairperson of Legal Sector Charter Council. I'm afraid to say Mama Christine, because I know I don't like it when at the shops and people say timer or uncle, but out of respect, Mama Christine Qunta, I'm not saying it in a bad way. I hope you'll allow me to say that. Welcome, and welcome to 702. Good morning to you. Thanks for choosing to speak to us this morning.
Yes, thank you, Thabo. You can call me Mama. I don't mind. Yes, good morning, and to you and to your listeners. Thank you for having me.
Thank you for agreeing to come through. And I won't go through the entire piece that you have penned for the Mail and Guardian, but there's succinct pieces or extracts there from, especially referring to not just BEE, but the transformation in the legal sector. And you are bemoaning the death of the legal sector, especially as it pertains to Black people. One of the things that you are saying, that the legal sector is no different. Recognition of this inequality led to the development of Triple BEE Sector Code of Good Practice. And you are saying that although there has been some progress, transformation in the legal profession remains insufficient. Black attorneys and advocates face two main challenges, and the first is lack of sustainable flow of quality legal work. Let's kick off with that one. May Christine.
Yes, thank you, Thabo. The Charter Council became operational in March 2025. So on our anniversary, we thought we should have a public outreach and inform the broader public about the legal sector code. The Charter Council is designed to monitor implementation with that code. And yes, you're correct. As I indicated in the article, the challenges, there are two I mentioned. There are others, but basically it is the absence of a sustainable flow of legal work, of quality legal work, because you remember, or you may remember, I don't know how old you are, but during apartheid, Black lawyers and advocates were restricted essentially to criminal work and to work like motor vehicle accidents, MVA, and the lucrative specialized areas of the law went to white lawyers. So what that has done is, come 1994, Black lawyers essentially remain on the periphery, and the private sector implements the same kind of discriminatory procurement that they did during apartheid. So they limit their work primarily, there are a few exceptions, but they limit their work to the large white law firms, and they exclude Black law firms. And in turn, for advocates, for example, the large white law firms, which generate a significant amount of work, they prefer to brief white advocates. So you find that Black advocates have to leave the bar because of that lack of sustainable work. Black law firms remain small. They're stunted by that problem. And if I can give you an example, the largest Black law firm has 18 partners. The largest white law firm has 396 partners. So there is clearly a problem there. And we are trying to solve that problem through the legal sector code.
You are saying as well in the article, and it may be, I suppose, refuted by optics and perceptions, and that's why I'm putting this on the table for you to clear that up for some of us who do not know about the profession and engage with it, perhaps through platforms such as various commissions and currently the Madlanga Commission that is there. People will argue that the plethora of lawyers that they see there are smart black lawyers who seem to be doing extremely well, and it appears that they are giving sufficient opportunities to showcase their prowess, their legal prowess, but also to make a living. But you are arguing here that discriminatory procurement practices keep law firms small, while many black advocates are forced to leave the bar. And the LPC statistics for 2024 show that the largest majority white-owned law firm has 396 partners, as you have said. What we see on TV, Mama Christine Qunta, and the reality, as we see some amazing advocates and senior counsel like Muzit Kakani to mention but a few, Ngogakai Tobi and many others that we see here, are they not representative of a large cohort black legal practitioners who benefit duly and have been empowered by legislation, by government, and by the private sector?
There is the state is the main source of legal work for black lawyers and advocates, and even the state, the procurement by the state from black legal practitioners is inconsistent. So some do very well, others don't. So what you see on television does not represent the full picture. So we have indicated in the legal sector code, although the state is the main support base for black legal practitioners, we want them in the first 2 years to give 70% of their outsourced legal services to black practitioners, black attorneys and black advocates. Going up to 80% in year 5, because the legal sector code is spread over 5 years.
And to what extent can we attribute this seeming problem to? Is it this discrimination? And I'm playing devil's advocate here. Is it based on the incompetence, inefficiency of black lawyers, or is it based on lack of marketing skills of black lawyers? What do we attribute this problem to? Why would it persist so heavily, even beyond 1994 to 2026, where we are right now? Ma'am Christine Qunta, are you there?
Can you hear me?
Now I can. I lost you for a few seconds. Please go ahead.
It is a function of an attachment to the ways of doing things that occurred prior to 1994. As I indicated in the article, the constitutional right to equality has not been accepted by everyone. The private sector primarily prefers to adhere to the apartheid-style procurement practices. And your question of whether black lawyers are not competent is not correct, because they go through the same universities, they get the same LLB, they do the same pupillage and candidate attorney program, they write the same examination, and it's only once they get admitted as legal practitioners that the discrimination kicks in. And it's important for us to dismantle that apartheid way of thinking, and the legal sector code does that. Now, the question we should all ask ourselves, if we claim to adhere to the Constitution and its provisions, why do we not accept the right to equality for black people in general and for black lawyers in this instance? And why is it necessary, more importantly, why is it necessary for legislation like the Black Economic Empowerment Act to compel people to comply with the constitutional right to equality as set out in 9 of the Bill of Rights? That's the question we should be asking.
Yeah, and why is it the private sector is still that way, by and large? And I remember attending as a journalist one of the ANC conferences. It was in Nasrec. I'm just not too sure which one, and I don't want to conflate issues. That's why I'm not referring to it specifically. But one of the questions that was asked in that press briefing to the subcommittee that was dealing with justice and peace within the ANC was that the plight of black lawyers is so much dire that even government does not necessarily assist to set a positive tone as far as briefings are concerned. And there are misperceptions that continue to prevail to date that black lawyers somehow are inferior to their white counterparts.
The impact that apartheid had on the psychological well-being of black people, we tend to underestimate that because mental colonization produces within the oppressed people an acceptance of that colonized narrative, that black people are inferior and white people are superior. And so what we have found within the state is that some black people do believe, the officials there do believe, that it is better for them to brief white lawyers because white lawyers are better. But it is important to indicate that by and large, especially within government, they do have policies in place to brief black legal practitioners. And to some extent, some of them exceed 70% per annum. But that's why I say it's inconsistent. It should be more consistent. We've engaged with them since the Charter Council began working, and we've had very good support from those state institutions, and we're entering into MOUs with them and negotiating that at the moment. So there will be change, hopefully, over the next 3 to 5 years while the council is in place.
Does it help that you have prominent black politicians and leaders who also don't express much confidence in black lawyers?
No, I think you just mentioned the various commissions. You'll see there's quite a few black lawyers there, which means that the Department of Justice has confidence in them. So it wouldn't be correct to say that they don't. But within organs of state, particularly those organs of state that have highly specialized areas of the law, I think there are challenges there in relation to that work going to black lawyers. And I can tell you, while black lawyers do not have some of the specialized skills, by and large, some of them have been with these large white law firms, and they have acquired those skills. So there's a very distinct difference between 1994 and now. So it is not correct to say that black lawyers do not have the skills, because they do have the skills, but you will find they would do the specialized work when they're in these large law firms. When they leave the law firms, they don't have clients because the private sector who gave them work, and even some of the private business people, will not trust that black lawyer. So it is a problem of mental colonization, which takes a long time to try, and that we have to deal with that and try and remove that. But the legal sector code presents a framework for that. And we've put in place targets for the large white law firms to brief 40% of the briefs per annum should go to black advocates, and half of that to black female advocates, and going up to 6% in year 5. We've also said that contrary to what is the situation now, where 72% of their partners and their directors are white and only 25% are black, we've said from the first 2 years, they must have 30% black partners or directors, going up to 50% in year 5. Now, some of them oppose it. You know that they've taken the Minister of Trade and Industry to court, which the matter is going to be heard next week. They oppose the legal sector code and they oppose these provisions. And they've asked the court to set aside the legal sector code. There's 4 of them, and they've teamed up with Solidarity, or Solidarity is also, let me correct that, they haven't teamed up, but they and Solidarity have opposed the legal sector code. It's Dennis Race, Weber Wenzel, Bowman, and Werksman. So that opposition to the legal sector code and to Black economic empowerment is very regrettable, but as the Charter Council, we are confident that we have the support of the profession. We've engaged with the profession by and large. They support it. They've asked for clarity on certain provisions. We've provided that. So I would say that the people within the profession who oppose the legal sector code, they're a minority.
I just want us to play this clip from Advocate Moses Kakanesi for just a few seconds, and I would want to hear your comment based on his assertions, Christine Qunta.
And I think the legal culture is difficult to crack because the educated are the worst victims of coloniality, because coloniality teaches them that they are superior, they are better. But it actually beats them up to submission intellectually. And I think that is why the legal culture is difficult to change. Because, first of all, we see Western modernity in general as superior. We see Europe and white cultures as superior. And I'm not talking about white people. That's how we see our view of ourselves. And that replicates itself from the legal profession to engineers, to architects, to politicians, to priests, to bishops. And it's only when we develop our own courage and a better image of who we are and our history. Our children, since when you and all the guys were young, even as critical as you are of our history, you start in 1652.
Yeah, and you are speaking to Susan Bofu-Walsh there in his podcast. And as I say goodbye, Mama Christine, asking you to look into that commentary. To what extent would we then attribute complicity of Black, or at least of some Black legal practitioners, in allowing the status quo to persist?
I don't think the fault is with legal practitioners. I think the fault is with the systemic, institutional, economic infrastructure inherited from apartheid. It has to be dismantled. It is being dismantled. Black economic empowerment provides a roadmap for that dismantling. The legal sector code is our contribution to that dismantling. And I think that's important.
I'll have to say goodbye. We've run out of time. I would have loved to speak to you for an extra hour or so. Christine Qunta, thank you so much for your time. Chairperson of Legal Sector Charter Council. 3 minutes to 11 o'clock.